Thank you for joining us today for Planning for the Inconceivable. My name is Lauren Lindsay. I'm a financial planner and Vice President and Private Wealth Advisor here at Westwood Wealth Management. Joining me today is my colleague, Shalitha Smodic, and I will let her introduce herself as well.
Hi, I'm so happy to have you all joining us today. My name is Shalitha Smodic, and I'm an Associate Vice President here at Westwood and also a Private Wealth Advisor.
We would like to start off by talking a little bit about the uncertain times that we're in right now. One of my favorite quotes as a financial planner is a quote by Benjamin Franklin. And that quote is, "Nothing is certain but death and taxes." And I think that quote is especially appropriate right now when we think about all the changes in our tax laws, our tax extensions being delayed, but they're not going away. We still have our taxes. And unfortunately, a very real side effect of the pandemic that we're in right now is death and people thinking about death. The estate planning attorneys that we're in touch with report that they've been busier than ever. And I think it's a combination of people having the time and the space to be able to consider these very important decisions and being able to have conversations with the people that are going to matter in these decisions, because everybody has slowed down a little bit to allow us to do this. So it's a very, very important thing that we're going to talk about today. We're going to be covering two topics. One is end of life planning or death planning, and one is incapacitation planning or disability planning. And these are probably not people's favorite topics, but as a financial planner, Shalitha and I know that they are very, very important as the financial plan. It's also very important because you do want to make sure that your wishes are carried out if either of these situations occur. And I say if because we don't know if people will be incapacitated, but really when is the correct word to use with end of life planning. And it's not something that people want to do. They don't necessarily want to consider their mortality. This is why people tend to put it off. But I will tell you, having been on the other side of this, it is one of the greatest gifts that you can give to the people who are leaving behind. The fact that they are able to carry out your wishes the way that you wanted them to is a very, very important piece of this puzzle. And so what we want to talk about today are some of the ways to help you accomplish that very important step.
So before we hop into everybody's favorite topic of death and incapacitation, let's briefly actually talk about what keeps us from planning from these life events in the first place. We all know, as Lauren mentioned, that death is inevitable. And I think most of us could throw out a story, either personal or anecdotal, of stories that we hear of people becoming sick or disabled, especially in the environment that we're in today. Yet year after year, studies show that Americans do not have a plan for the end of their life. And I think there are actually several reasons for this, and I'm just going to highlight a few of those reasons for you all today. So the first is actually very simple. Conversations about death and incapacitation can be difficult and unpleasant. No one really wants to talk about losing a loved one or planning for when someone has passed away. And even as a financial planner who talks about these topics often and thinks that they're pretty comfortable talking about death and incapacitation, as I see it all the time, when I was faced with having this discussion with my mother about her end of life preferences, it was a very different situation. It was tough, and it was truly uncomfortable to consider a situation where I'd be planning for a world that my mother was no longer a part of. It can be equally as difficult to think about your own death or your own incapacitation. Planning for death and incapacitation also means that we have to make tough decisions, like who will we trust with making decisions for us when we cannot make decisions for ourselves. This can become even more difficult when it is uncertain or unclear of who you would have to step into these roles. For others, it could be that they do not think that their financial situation is large enough or complex enough to warrant planning for these life events. And on the opposite end of the spectrum, there are people who feel that their situation is so extremely complex that planning for it or even tackling it, looking at these issues, feels daunting and stressful and just way too large to begin. I will also throw out there that I would much rather spend money on my next vacation or a new pair of shoes than on estate planning documents. I just do not get the same level of excitement from paying to get my new power of attorney updated as I do with planning for that next big trip. Even though I very much value this, that's still just not as much fun, I must tell you. And finally, I also want to point out that as much as Lauren and I are very interested in this topic, we spend a lot of time reading about estate planning and these types of subjects. And one of the phrases that I quite often see when I'm looking at articles about planning for the end of life or about incapacitation planning, you see phrases like, get your affairs in order. And a lot of times you get to the end of these articles with questions like, what exactly does getting my affairs in order even mean? How do I even begin this process? And is what I currently have in place sufficient? So a lot of times you read articles with the best intentions of doing just this, starting this planning, but you're left with more questions than you had from when you first started to begin with. All of these obstacles to starting estate planning are valid and understandable. However, despite all of these unpleasantries, I still want to encourage all of you to plan for end of life anyway. So now I want to talk about some of the benefits of planning for this, even if it's a little uncomfortable to begin with. So first and foremost, planning for death and incapacitation ensures a successful transfer of assets, which basically just means that we're ensuring that the things that are important to us get to the people that are important to us. So you want to make sure that you're getting a say in where things are going and that you set your circumstances up so that they actually get to those people or charitable organizations if that's your desire. But for me, two of the top reasons that I value end of life planning is the opportunity to decide and peace of mind. Planning for these events in advance allows you the chance to share your wishes with your family and your caregivers in advance and allows you to share how you want things to be handled when you may not be in a place to answer those questions at that time. You also get to decide how you want to have the end of your life go. So you get to share your thoughts and opinions on things like do not resuscitation orders. What point do not want people to take further action to prolong your life? For others, like Warren, it's very important to be able to decide who will be guardian of your children, rather than have states decide that for you, which vary from state to state, may not go to the person that you think. As Lauren has mentioned to me before, funerals in Louisiana are also like huge celebrations. So people from some areas, the biggest area that they would want to provide their feedback on is actually the burial itself. And even for my mom, I was so surprised when I had this conversation with her that actually planning for her burial, she wants to be cremated and not be included in our family's plot, was the biggest driver and biggest thing that she wanted to share with me about her end of life plans, which was very surprising to me. But on the other hand, that's what was most important to her. Knowing that there's a plan in place also gives so much peace of mind that my wishes have been shared with my family members and all of the correct parties so that I know that things will go smoothly at the point at which I am incapacitated or I've passed away. Knowing that my assets will be shared in the manner that I want and that I have enough insurance to replace my income needs for my family just ensures that they'll be taken care of if something was to happen. And so for me, it's not as much of a concern for me on a day-to-day basis if something were to happen to me because I know that these plans are in place and I know how the people that I love will be cared for. And even funny things, guys, I have actually one insurance policy that is purely to purchase a sports car for my husband if I died before we got to check this bucket list item off of our joint bucket list together. And that doesn't actually make me sad. It makes me smile knowing how surprised he will be when he gets to open that envelope and see that he has gotten a new car. um, so finally, having written plans ensures an easier transition for both of your assets and for the people that you love to move into this next chapter of their lives. If you have written documents for the people that you are leaving behind, they have certainty on what your wishes were and how to carry them out. At the end of a loved one's life or the incapacitation of a loved one, perhaps too soon, is a very emotional time and can be very difficult for anyone to make decisions at that point. So planning in advance truly allows you the opportunity to make that transition easier for them, not just from a practicality standpoint, but also from an emotional standpoint as well. So now with those benefits being shared, I'm going to turn the mic back over to Lauren to discuss some practical tips and steps to plan for death and incapacitation.
Great. Thanks, Shalitha. As Shalitha discussed, this isn't the easiest thing to start. Even when you're comfortable with the topic the way that she and I are, I do think it's something that I've become more comfortable with over the decades that I've been doing this job, because you get presented with these situations. And I can tell you so many stories about grateful clients who said, this was a hard thing, but thanks to you, it went without a hiccup and all the wishes were carried out. So my very first recommendation is to start early. Do this before you have illness. Do this while you have time. If you have young children, for me, the number one reason to be doing any kind of estate planning is to plan for the care of minor children, as Shalitha mentioned. Um, Again, every estate planning attorney that you meet with will have heard a similar story. So it may be something to do with blended families. It may be to do with a special needs child. You may have all kinds of reasons why this is a hard thing to start. All of those reasons are the very same things that make it so important. So start thinking while you can. Don't leave it until it's urgent and you have to do it because someone has had an accident or someone is on their deathbed. I can tell you that that doesn't make for the best laid plans. The next thing I would recommend is to think it through. I used to be a high school English teacher, so for me, writing things down is very, very important. And I have found that doing that with clients and having them think through the considerations, having them write down who the people are going to be, having them write down the pros and cons of using those people, that is very, very helpful. We have worksheets at Westwood that we can certainly work with you to kind of go through this. And a lot of estate planning attorneys will as well, as opposed to, you go to a meeting at their office and that's the first time you're having these conversations. As Shalitha talked about with the barriers, sometimes it's that you don't know who to name for these people. And so thinking it through and talking it through with your advisor can be really helpful to say, well, this is a good person, but this is my concern. I will definitely say something in writing is better than nothing. And I do think that kind of doing a draft and putting down your thoughts is a really, really helpful way to start. After you have the people in mind, the next thing would be to have a conversation with those people. The number of times that I've met with someone and had that client say, oh, well, no, none of these people know that they're in my will or on my list or things like that. We recently went through this conversation with my father-in-law, who has named my husband as his executor. And he was reluctant to share the contents of his will, which is absolutely fine. But I was very, very grateful that he let us know that he had made the change to my husband because it had been another child previously, so that we can prepare. We can ask him the questions. We can make sure we know where everything is. It's not a surprise, we open up his will and, oh gosh, you're it. It's also very important to make sure that that person is comfortable. I am, for example, a guardian for friends' children if something happens to them. And I'm very, very glad to know that I'm in those documents so that if something happens to those people, it's not a surprise that they're coming to me. These are also documents that are changeable depending on circumstances. And so if you need to change people for different reasons, make sure that you're updating those people as well. But you want to make sure that you've talked to these people. The last piece of all this is to make sure that you have these wishes documented and written down. The number of people who have said to me over the years, oh yeah, my children know what I want. We've talked about it all the time. Talking about it is fantastic. However, in the heat of the moment, when you are suffering or somebody has had an accident or something like that, all the conversations in the world go right out of your brain. So making sure that you have your wishes written down, that you have the proper documents in place, that you perhaps have ancillary documents to guide those people if they need them. All of those things are one of the greatest gifts that you can give to the people that you're leaving behind. It also helps to ensure, as Shalitha said previously, that your wishes are carried out. And that is a lot of peace of mind as well. I want to talk a little bit now about the documents that are involved. And it is important to know that there are particular people involved in these specific documents as well. But I want to just quickly kind of go over some of the things that you might want to consider and how these documents are used. So one of the most important documents is your will. And your will is where you decide all your stuff. So this is where we talked about children. This is where you would name guardianship for your children. This may be where you name any special family heirlooms or antiques. You may list bank accounts in here. Anything that is going to be considered an asset that's not going to transfer through a beneficiary form is going to transfer through your will. So it is important in the will to list what those things are and who you want to have them. Some people may supplement this with something called an ethical will, which talks about your wishes, and it may talk about why you want different people to have different things. That may be a conversation you have outside of it, but the will is going to be the first starting point. The person who carries out your will is the executor, and the executor is an important job because that person needs to make sure that they're very thorough. They're going to need to coordinate with the different banks and the places that you may have these assets to make sure that they're transferred according to your wishes in the will. So the will is the good starting point. In conjunction with the will, a lot of people may have a trust. Now, these are all state-specific documents. Different states have different requirements for probate. One of the reasons why some people may set up a trust is to avoid probate. That would usually be what's called a revocable trust. An irrevocable trust, meaning you can't change it, may be a way to hold an asset outside of your taxable estate for various reasons. When the exemption was a lot higher, these were very common, but you may also want to hold an asset outside of your estate for reasons of divorce, lawsuits. There are a lot of reasons. So again, when you're meeting with your estate planning attorney, it is very important to tell them, here's my situation, here's the considerations. And I promise you, it will not be the first time they've heard those set of circumstances, but it is very important to share with them, here are my concerns, here are the things I'm trying to accomplish, so they can help you set up the proper instruments. I also want to mention that I think it's very important to use an estate planning attorney. There are a lot of lawyers out there, and there are lawyers who will quote unquote do a will, but that doesn't necessarily mean that they're an estate planning attorney. So it is important to check their credentials and make sure that they know what they're doing. And again, like I said, these are state-specific documents, so you do want to hire an estate planning attorney in the state of your main residence so that they can make sure that they're adhering to those state requirements. So those are two of the death documents. Incapacitation documents include a medical power of attorney and a financial power of attorney, which may also be called a durable power of attorney. So the medical power of attorney is where you're going to list your health wishes. Do you want hydration, nutrition? Do you want to be kept on life support? I have seen different levels of a medical power of attorney, and some of it just say, this is the person required to make those decisions. It may not be your spouse. The spouse may not be the best person to carry out these wishes. Your children may not be the best person to carry out these wishes. It may be, in some examples, a medical professional that you're close to, especially if you don't have a lot of family. But it should be somebody who knows what those wishes are, and the best medical powers of attorney are the ones that will go ahead and outline what those wishes are, again, so that people aren't having to remember this off the top of their heads. Now, if you go to a hospital and have a procedure done, they will likely have you sign perhaps a do not resuscitate order or some kind of healthcare proxy. And a lot of times that is specific to that hospital. It may be specific to that procedure. They will ask if you have this on file. This is a very, very important document so that your medical power of attorney, that person, knows where this is held. In conjunction with that, we have a financial power of attorney, which is also sometimes called a durable power of attorney. This is the person that, if you are incapacitated, can make the financial decisions for you. They can pay your bills, they can file your taxes, they can make gifts. In this document, you can say, yes, I allow my financial planning and power of attorney to do this. Or you can say, no, I'm going to restrict that power. They're not going to be able to do that. And again, this is very easy to set up. It's very easy to make your wishes known because there's basically a checklist and you initial, yes, I want them to be able to do this. No, I don't want them to be able to do that. This is a really important document to have in place if something does happen to you. In conjunction with these, we also have a beneficiary designation form. So that is a federal document. If you have a retirement plan or an IRA or a life insurance policy, all of those will have beneficiary designation forms. Those are going to be assets that pass entirely by those beneficiary designation forms. They are not going to go through your will. So it is very important that you have your will and your beneficiary forms coordinated. Now, what's nice about the beneficiary designation forms is they're a little bit easier to update than a will. If you want to change them, it's generally a matter of getting a copy of it, getting it signed, and sending it back in. You can set these up for as many different people as you want. There may only be 4 slots on there, but if you want to do 100 different people getting 1%, that is possible. You just do an addendum to it. You can leave things in a beneficiary form not only to individuals, but you can leave them to a trust. You can leave them to a charity. So there's a lot of flexibility here. It is important to note that a beneficiary designation form is going to supersede your will. So if these documents do not match, that is a very important thing to consider, that the beneficiary form is going to overrule it because it's a federal document instead of a state document. In these documents are what I would consider to be the important must-have documents, the vital documents, if you will. And we talked a minute about life insurance policies. Life insurance and disability insurance can be very important pieces of this puzzle as well, but I wouldn't consider them to be vital because not every person requires them. That is a situation by situation case, and you would want to talk to your advisor about that to make sure that that's something that you have in place, you need to have in place, how to get it in place if you don't have it. But if you don't have someone generally who's relying upon you for income, you may not need either of these documents. So I do want to talk a little bit now more about what I would consider to be other nice to have documents in place, beneficial documents, if you will. So these are going to be things that are going to be very helpful for those folks that you've listed in those documents that are having to carry out your wishes. So the first one is some kind of document that lists your assets and liabilities. So what do you have? What do you owe? And where are things held? So for example, one of the things that is always, I don't know why, difficult, where's the safe deposit box located? And the executor will say, gosh, I know they have one. I'm not sure if I know which branch it is. So all of these things that you may have told your kid or your spouse 100 zillion times, they may or may not remember it. So it is very important to have these things, especially when they change. If some of these things are password protected, you may want to have a password set up so that your spouse or whoever it's going to be can access things online if they need to, especially in the event of your incapacitation. So that's very important. I also like to have a letter of instruction for the executor. So this isn't going to be part of the will necessarily, but this may be, again, things about where these assets are located. It may be why you're leaving things to different people. We talked about the ethical will briefly. It may be a story about how you came to have a particular possession and why you want this particular person to have it. I love things like that because they are very meaningful to the people who get to receive them, to know why they were chosen and to understand the family history that perhaps goes along with them. I also do like to have a letter instruction for trustee, and this is especially important for the trustee of a testamentary trust for minor children. So, for example, my daughter is 10. She's an only child, and we have a testamentary trust created for her in the event that we pass away before she becomes of legal age. I also have a letter that goes along with it, and the letter specifies things like I would like it to be used for education, I would like it to be used for travel, I would like it to be used for the purchase of a house. And it talks about, for me, why these are important things. So again, it's passing along my values as well as giving the trustee and my child some guidance as to why these things are important to me for her if I'm not going to be around. Another beneficial document that I like, and I do find for some people this is a great way in, is a funeral wish. And this can be provided by a funeral home. So some people are very organized and they will have a package paid for and organized with a funeral home. But even if you don't, a lot of people have very strong wishes about their funeral arrangements. And Shalith had mentioned this earlier. I worked in Louisiana for a number of years, and funerals in Louisiana are no joke. They are one big party. So this was a very popular thing to do in my office because people had very specific requirements about this is where I want it to be. This is the kind of alcohol I'd like to have served. But basically, most people have very specific ideas about how they want to be memorialized. It's your last party, it's your last send off. So if you are trying to get someone to make some of these decisions, this may be a way in. But again, I think this is very, very helpful for those you're leaving behind. It's important to remember that the will is oftentimes not read until after the person is buried. And it's very upsetting to open up a will and say, oh gosh, Aunt Judy wanted to be buried in her red dress and we buried her in her blue dress. So it's good to have these documents outside of the will. And again, to have the person who's going to be responsible for executing these decisions have a copy as well.
So now we're going to turn our attention back to how you actually go about starting these conversations with family members or even with other loved ones that may end up being future caregivers. Earlier in this presentation, I mentioned that talking about death and incapacitation can be difficult. So I didn't want to send you all off without talking a little bit about how to prepare for these conversations. So my first tip is to prepare for what I call big feelings. So talking about topics like this, like death or incapacitation or sickness, or in general, some long-term big future things that may happen, it can really cause anger, it can cause sadness, it can cause a lot of emotions to be dredged up, but it can also cause grief. And sometimes this grief is not necessarily associated with death or disability itself, but it can be an anticipatory grief that is really dealing with tougher subjects like loss of independence or loss of youth, things like that as well. Even if they're not even close to that, even if they're very young or if everyone's in very good health, a person can experience this kind of grieving process just by having these conversations. So it's very important when you're having these types of conversations with family members to not only just pay attention to the content of the conversation as you're noting down what people's wishes are, but you also want to pay attention to the feelings that are coming up during these types of conversations as well. The second tip I like to give is to ask what is important. So for me, before I had my end of life discussion with my mother, I had no idea that the most important thing for her to tell me was her burial instructions. For me, that's like the last thing on my mind when it comes to planning for the end of life. For me, the thing I care about most is ensuring that my husband doesn't have to struggle to make decisions after I'm gone, that transition to having me around to not having me around is easy for him. It's not difficult from a planning perspective. For others, it could be a variety of things. Some people may want their mother's jewelry to go to a specific grandchild or their specific charitable donations that they want to be made. So what's important really will vary person to person, but you want to make sure that these items that are most important to them, to your loved ones, and to you are being discussed. Also, when you're talking about things that are important to that person, it's a good time to explain how end of life and incapacity planning can ensure that the things that are most important to you, those most important wishes, are documented and how that can benefit them in making sure that this actually gets done. It can be a great call to action to actually get started on this overall process. So by highlighting what's the most important thing that you would want me to know before you pass, or if something were to happen to you, can be a great way, a kind of good transition into the overall conversation about these tougher topics as well. So with this, I always like to tell people as well that you are not alone in trying to figure all of this out. Just from the explanations that Lauren was telling us, there are a lot of considerations that go into end of life and incapacitation planning. And I want you guys to know that Westwood does offer several financial planning services that can be helpful when planning for end of life and incapacity. So we're happy to review life insurance policies to ensure that you have enough coverage. We build financial statements to show where your assets are, where they're being held. We're happy to review your wills to ensure they're consistent with your wishes, and to even diagram those wills for your loved ones so that you can see exactly how your assets will flow. We also offer take-home questionnaires and checklists that can be great guides in thinking through topics like burial arrangements, who you want to act as executor, who your backup would be if the first choice is not available, and the same for trustees and powers of attorneys. And this really helps to get your thoughts in orders before you actually have to make these meetings with estate planning attorneys. So to kind of have that information in your head before you get there. We also have a sample letter of instruction that can be filled out with some of these beneficial things that Lauren has listed that would be nice for someone to know. We have a document that you could fill out that would show information that would be nice for a survivor to have. And they range from things like where your assets are held and who your actual attorney or your CPA is or your financial advisor is, to other more personal things that you could fill out and leave for them that may include passwords to various things that need to be shut down, or even current medications that you may be on, so that they know what to tell someone if you weren't able to explain that if you ended up in the hospital or something. Finally, if you need actual referrals for an estate planning attorney, we're also happy to provide contacts for people that you can get in touch with to actually draft these type of documents as well. So I always want to make sure that you know that you are not left to figure all of these things out on your own. Your private wealth advisors at Westwood are available to help kind of make this whole process a little more simple. So with that, that concludes today's presentation on planning for the inconceivable. If you would like to receive any of the resources or services that we've discussed in today's call, or if you have any additional questions about either of these topics, please reach out to your private wealth advisor, and they will make sure that we can get those documents and resources to you. Thank you again for spending some of your day with us, and please enjoy your afternoon. Bye-bye.